presentation, Digital Accessibility Law for Developers, Designers, All of Us. Our speaker today is Lainey Feingold. Lainey is a disability rights lawyer, author, and frequent national and international speaker about structured negotiation and digital accessibility law. She's the author of Structured Negotiation, a winning alternative to lawsuits. She also was the individual recipient for the 2017 John W. Cooley Lawyer as Problem Solver Award. We are delighted to have Lainey with us as the presenter today, and I will turn things over to you.
Okay, thank you. So am I good with the sound? And
yes, you sound great. Go ahead.
Okay, good. Well, thank you all for coming, especially those on the West Coast like me where it's early, so I appreciate that. On the title slide, I have my website, which is lflegal.com. I have a lot of digital accessibility articles and posts that I've wrote and thoughts that I have, so I invite you to go there. Many of the cases that I'll cite, there are links on the website in the legal update tab where you can actually read what a judge might be saying or what a settlement agreement and structured negotiation said, etc. I also have up here my Twitter, which is @LFLegal. For those of you not on Twitter, I really recommend it for digital accessibility. It's a really great community. I see the participants, and some of you I have gotten to know and become friends with because of Twitter. So that's why I have the Twitter up there with the little Twitter bird, which you'll see throughout the presentation. If I think something's very tweet-worthy, I put that up, not that I'm suggesting that you tweet. Okay, now I have to figure out how to move the slides. Here I go. Okay, so Kevin just told you about me, so just real briefly, other things. I've been doing this work since 1992. I've been doing the accessible tech work since 1995 when I started with Talking ATMs, and I did my first web accessibility agreement working with the blind community in Bank America in 2000. So I've seen a lot of the field develop, the technology develop, the legal space develop. Like Kevin said, I'm a speaker and trainer. My book is called Structured Negotiation, a Winning Alternative to Lawsuit. One good thing about being a speaker is I get to go to different places. And last year I had the privilege to go to both Australia and Canada to talk about these issues. And in both those countries, they start with remembering our place and the Native people who have been on the land before us. So I've adopted that. It's hard to create a community in a webinar where I'm sitting here in my office and kind of talking to the void. But for the next hour and a half, we are a community of people who care about digital accessibility and making the world, and especially the digital world, available to disabled people. And I like the practice of remembering our place. I put in here 3 of the native tribes of California where I live, the Pomo, the Modoc, and the Washoe, and a picture of Berkeley, California, where I live in its natural state where we can still hike in this space. That I put the picture up with the trees and the distant mountains. And the reason I like thinking about it is not just to honor the Native people, which I learned, as I said, from Canada and Australia, but to kind of remember where we are in history. And, you know, 100 years ago, even 50 years ago, people weren't working on the accessibility of digital. There wasn't that much digital. When I started in 2000, working with Bank of America, online banking was barely a thing. The App Store didn't open until 2008. So we are in a very privileged time in terms of creating accessibility in the digital space. And I like to see the arc of history and know this is where we are right now. And if you're on this call, it means you care about this issue and that you're using your time and your work and your energy and your passion to do this work in this time, in this space. So I thank you for that. The not-so-fine print of this presentation is anything I say in the webinars, anything I write on my website, not legal advice. I am a lawyer, and I do these presentations to share what's happening in the law with primarily people who aren't lawyers, because the law is a driver right now, as we all know. And accessibility is a civil right, as we'll talk about, so I think it's important to know what the law is, but it's not legal advice. So if you think you have a legal claim or you get a lawsuit, or you're working with a company, you need to call a lawyer to talk about your own particular issues. That I put the little Twitter board there to remind people the updates are not legal advice. The goals of this session to help you all make sense of the legal landscape, which is actually changing as we speak, to help shift from fear to motivation. There's a lot of fear based on the legal space. No one wants a lawsuit. People are afraid of lawsuits. People don't understand what's happening. And I think the law can really be a motivator for all of us, all of you who are champions because you're on this call, so you care about this. The law can be a motivator. We just need to learn how to talk about the law in that way. Whatever your role is, we don't have time to have everybody type in their role, but from those of you who I know, who I see on the list, I know you have varied roles in the digital space. How can the law help, whatever your role is? And how can you leave today, excuse me, how can you leave today and make sense of what's going to happen tomorrow? Because I can assure you something will happen tomorrow that I can't necessarily predict, can't really predict at all on this webinar today. So those of you who've seen me speak before know I like this idea of keeping the law in your pocket. So I have a picture here of a pocket with tools like a scissors and a pen and a tape measure, and the law is a tool like that in my view, and the law is something that can help all of us in whatever our role advance the goals of making the digital world more inclusive. So hopefully the goals of the session will be met, and let's dive in. The first principle, the reason the law is involved with this at all, is that accessibility is about people. I have two pictures here. I'm really looking for a great picture of people, a crowd of people that's diverse and integrated in every way. And I haven't quite been able to find it. The picture, one of the pictures up here is pretty diverse in terms of gender and ethnicity and race. There's a wheelchair rider, but the age of everybody is quite young. It's a photo I got from someone named Carl Martin, who has a website, More Than We, and it's a great picture of diversity, not so good on age. So the other picture is very good on age diversity and also race and gender, no visible disability. So I use those two together. If anyone has a great picture of diversity, I hope you will send it to me. I also like the picture on the right. Even though there's no visible disability in it, it's a reminder that many disabilities are not visible. Accessibility goes beyond what people need who are blind or deaf or have mobility issues. So in that way, the diversity picture is good too. So accessibility is about people, and those people have legal rights. So yes, everything we're all doing, the standards, the testing, the quality assurance, it's all important, but we can't ever lose sight of the first principle that accessibility is about people with legal rights. And here's just, I know many of you call people users if you're in UX or web development. We tend to think web, who are users. I like breaking it down to the type of users, who are the people. And here's just a small list: students, shoppers, patients, customers, investors and taxpayers, sports fans, applicants and employees, citizens, voters, and diners and restaurants. These are just some of the type of people that rely on accessibility and that have been part of legal cases, that have been relying on the law to make the digital space more accessible. So again, if we have more time, I invite you to think about what people you're designing for, developing for, making policy for, and always go back to that core principle that accessibility is about people. And homeowners. Yes, I did a structured negotiation for a blind homeowner to make sure the mortgage information that she was receiving was accessible to her. So because it's about people, accessibility is a civil right of disabled people. And that's really why the law is involved. And at its core, that should be a motivator for all of us, that accessibility is a civil right, in many countries referred to as a human right. for our purposes, it's the same here. And I have this illustrated. I always use this photo because I love it, and it just encapsulates what the civil rights issue is. It's a march as part of the run-up to the Americans with Disabilities Act with a banner that says, "Injustice anywhere is a threat to justice everywhere." It's a Martin Luther King quote, and it's being held high by disabled people marching. It's great for this week because tomorrow is the 28th anniversary of the Americans with Disabilities Act. And I actually saw a picture on Twitter yesterday that the Nickel Disability Group is having a march in Washington. I think they had this very banner still there. So accessibility is a civil right of disabled people, and that's why it's even in the legal space to begin with. Why is that? Because with accessibility, we have participation and inclusion, which is why I have a picture here of smiling people, one who appears to have a disability, one who doesn't. Inclusion and participation is what accessibility is about, and equality. And without accessibility, you have what this picture shows, which is this sad-looking woman looking in from outside. Because without accessibility, people are left out and there is exclusion. So at the core, if you have to leave and you can't look at the archive, this is why the law is involved, and this is the goal of the legal space, to make sure that people are not left out and that people are included. And without accessibility, there's discrimination. So you have a choice, whatever your role, whatever decision you have to make, whether you're, like I said, policy, developer, designer, lawyer, you have a choice. You can either do your work with an open door for inclusion, or you can do your work with a closed lock door, which is the two pictures I have up here. One, the open old door, I like old stuff, so I have an old door with the light shining through, and the other one is an old door, locked up with an old-fashioned lock with a key. And that's our choice. Every day when we're making decisions about how to code and how to test and how to design and what policies and what training and all the elements we know make for an accessibility program, we have a choice to have an open door that's going to include disabled people or a closed door. And judges agree with this. I have a couple quotes here throughout the presentation. I don't really like text-heavy slides, but now that there are more judicial decisions on accessibility, and we're going to be talking about those, there's more. I don't just have to say it, oh, Lainey thinks this about civil rights, but here's a great quote that from a judge in an accessibility case. Today, Internet technology enables individuals to participate actively in their community and engage in commerce from the comfort and convenience of their home. It would be a cruel irony to adopt an interpretation of the ADA that the company in this case was Blick Art Supplies, to adopt an interpretation of the ADA espoused by Blick, which would render the legislation intended to emancipate the disabled from the bonds of isolation and segregation obsolete when its objective is increasingly within reach. Yeah, that's what the ADA is all about, emancipate the disabled from the bonds of isolation and segregation. This judge, Judge Weinstein, a New York judge, is 96 years old. And I like saying that because if he can get it, we can all get it. So accessibility is about inclusion. Accessibility is about not discriminating. It's about participation. It's also about a right to information. It's another reason accessibility is a civil right. Information about education, transit, voting, all sorts of services, finance, healthcare and retail, employment, community, sports. These are, again, just some of the types of information where the law has gotten involved to say, yeah, disabled people can't be excluded. Digital, web, mobile, kiosks, et cetera, have to be accessible. Accessibility is also about confidentiality and security. And I like mentioning this. This is an aspect of the civil rights piece, and also should be a motivator, and is also a tool in your pocket, because all companies now and government agencies, education institutions, they understand confidentiality and security. No one would intentionally put up content that would allow a big security hole or would breach confidentiality of students or patients. People wouldn't do it. But that's what accessibility, or better stated, that's what the lack of accessibility is. Because if you don't have accessibility and a person with a disability can't independently access information, they need to get help, and that means the information is not confidential and secure. So we need to do our best to get organizations that we work for to recognize accessibility just the same way they recognize confidentiality and security. So it's another aspect of the civil rights, also privacy. Privacy, confidentiality, and security, core principles of the Internet best practices, digital best practices. Accessibility can't be separated from those. Okay, I see there's a thing. I'd love to have some references for that Blick case. Yes, in the legal update tab of my website, which is lflegal.com, you'll see a lot of articles. I used to do a legal update like every 6 months and put everything in one article. Well, there's too much to put in one article. So if you scroll through the last year or so of articles, you will see the ones about recent cases, and I have more quotes from Jack Weinstein's case in Blick, and also links so you can read the whole order to yourself. I think it's like 40 pages. It's beautiful. So thank you for those of you who are putting, 3Play Media must have done a webinar on it, and you can read my take on it on my website. So thank you for that. So why be afraid of that? If accessibility is about inclusion and civil rights and confidentiality, let's remember that and not be scared by the lawsuits. That's really a message that I think is important and something to put in our pocket. So here's a legal equation for access. I've used this before, those of you who've heard me speak, and I like to mix it up and try to think of other analogies, but this one is so, I just haven't thought of anything better, so if anyone does, you can share it with me. But the legal equation is that you need a foundation of laws and regulations, and you need advocates who are going to use those laws and strategies for how to use those laws. And if you put together the right combination, you have greater accessibility. So foundation and advocates and strategies, greater accessibility. So now we're going to talk about the foundation. The foundation is strong, which is why I keep using the same picture. Again, apologies for those of you who have seen this before. Send me other ones you think represent the fact that we have a strong foundation for accessibility in this country, other countries as well, but many countries do not. Many countries are looking to what's happening in the United States. There may be some issues about some of the strategies, but the foundation itself, the ADA that we're celebrating tomorrow, 28th birthday, is strong, like this picture of cement blocks with mortar and a guy, like you can see this thing is going to last for 100 years or more. So it's a strong foundation, and let's talk about it. So the U.S. laws and policies that make up the foundation, we have the Americans with Disabilities Act. It covers the public sector, the private sector. It covers employment. It requires effective communication. It requires people covered by the law to effectively communicate. And you cannot have a digital content that's inaccessible that effectively communicates. So, we could spend 90 minutes just on the ADA and the sections, but I'm just trying to give you a bigger sort of bird's eye picture of it. The Americans with Disabilities Act is really a critical part of that strong foundation. And other countries look to us. I've been speaking to people in various places like, we want to make our laws stronger, or we want to make laws where we don't have them. We also have in the United States Section 504, which is for federally funded, when the U.S. federal government gives money to states, universities, programs, that money has to be spent in a way that doesn't leave people out. And that means accessibility. So it's not all that complicated. The basic idea is that if you're going to take money from the federal government, you can't take it for some people and not everyone. And that's why when we get back to the first principle is accessibility is about not excluding people, we remember, oh yeah, that makes sense. If I'm taking federal money and using it in education, say, for a website or a mobile app or a kiosk, and students are going to be using it, you can't pick and choose and say non-disabled students can't use it. So Section 504 is part of the foundation. Federal employment, this section's about federal contractors and employees, same idea. If there's going to be federal employment, it has to be for everyone. And that's an area where, digital is more and more important as it's so key to pretty much every job today. Federal procurement is a section that most of you are probably most familiar with, Section 508. That has, again, to do with the federal government. When it buys something, it has to buy something that works for everyone. Yes, there's a lot of regulation and procurement and I forget what the FAR, I'm forgetting what it stands for right now, but there's a lot of detail, but in terms of what's in the pocket, what's in our pocket to use this, it's like, oh yeah, we're selling to the federal government, it has to work for everybody. That's what these laws are about. There's a separate law for accessibility for airlines that requires kiosks and websites to be accessible. And Section 1557 of the Affordable Care Act is a requirement that healthcare organizations involved in Accessible Care Act have to make sure their technology is accessible, websites, et cetera. Again, for the same reason. These are federal programs, and again, we're talking federal in this. Right now I'm talking about the federal laws and policies. Bottom line to be in the pocket is that when federal money is spent, can't pick and choose between people with disabilities and people without, and that means accessibility. Are there ADA regulations? Are there ADA regulations? The answer is no, which is why I have this big red circle on top of the ADA regulations. And you'll hear people say, and maybe you hear it in your own organization, you certainly hear it in the political chatter, oh, the area is gray, we don't have regulations. And we were supposed to have regulations. There were proposed regulations beginning in 2000, and I and many other people testified before the Justice Department and wrote pages and pages of comments. Well, fast forward to 2018, we don't have regulations, but we still have the ADA Foundation that is strong. So, and we have cases, we have Justice Department orders recognizing accessibility is required by the ADA, which we'll talk about in a minute, but we don't have ADA regulations. So I have two slogans for that. One is that ADA web regulations are inactive, but the ADA is not. That's a pocket thing. ADA web regulations are inactive, the ADA is not. I have a little Twitter bird for that if you think it's Twitter worthy. And the ADA web regulations are dead. Yeah, they're more than inactive. They use that word. They're actually dead right now. But the ADA is alive and well, which is a great thing to say today, the day before the 28th anniversary tomorrow. So the ADA web regulations are dead, but the ADA is alive and well. Thank you to the captioners. I see the captioning is now coming up through the caption pod on the Adobe Connect, so thank you for that. So yeah, this is basically the answer when someone says, oh, it's a gray area. The ADA is not a gray area. The ADA requires inclusion, prevents discrimination, requires effective communication. And judges agree with this too. So I have a couple quotes just to drive home the point. I've been saying this for a long time, and it's nice to have some, not just me, other advocates and plaintiffs' lawyers have been saying this, and now judges in the Department of Justice has said it for a long time that the ADA covers websites even though there are no regulations, and now we're starting to have judges say it. So one of those judges was in a case called 1-800-FLOWERS, which is why I have a nice picture of flowers on this page, and the judge said, the DOJ, Department of Justice's rulemaking process has no impact, I use blue, emphasis for color. DOJ's rulemaking process has no impact on the fitness of this case for adjudication. Adjudication is just a fancy word of saying the case can go forward. So that's one judge, and then that's a 1-800-FLOWERS judge. And there was another case against Blue Apron, which is a meal delivery service, which I have a picture of here. And that judge said the court will not delay in adjudicating plaintiff's claim on the off chance the Department of Justice promptly issues regulations it has contemplated issuing for 7 years, but has yet to make significant progress on. And again, these court orders, the full orders, are linked in the articles under the Legal Update tab on my website. You could probably Google them as well. The court will not delay, and this was 2017, so I would say it's not really an off chance that the DOJ promptly issues, because they said they were going to do it in 2000 and it never came. So most of the cases that are happening now, we'll see in a minute, the judges are getting involved in very early stages when someone files a lawsuit and the company decides to fight the very fact that the lawsuit's in court, and they file what they call motion to dismiss, and that's why we're getting these orders where the judges are saying things like this: you can keep this case in court because we're not going to wait around for the Justice Department to issue its regulations. So the takeaway, excuse me, the takeaway on the ADA web regulations, again, repeat, the regs are dead, the ADA is alive and well. That's part of the strong foundation. Okay, in addition to the federal laws that make that foundation strong, in the United States, many states have laws that require and impact accessibility. So here's just a few of them. We have state-funded IT requirements that say state-funded IT has to be accessible. That's like Section 508. That's like Section 504. We have laws in most states that state procured. When states are going to buy technology, if you're selling to a state, that has to be accessible. Many states have anti-discrimination laws that are similar to the ADA. There are local laws. Some of the New York cases are based on there's a New York City civil rights law. California has a specific law requiring state websites to be accessible. Massachusetts has a constitution that's been used. Where are the lawsuits? Most of the lawsuits right now are in New York and California based on the types of state laws those states have, but we'll see in a minute that the lawsuits are in other places as well. But the state laws are an important part of the foundation, and in today's political climate could grow even more important if the federal laws or the federal enforcement of those laws changes over time. Beyond the U.S. is a strong foundation. We can't get into the whole international world here, but I just want to give you a few resources. You are part of a global movement. If you feel frustrated in your job convincing whoever you have to convince, your team, your supervisors, the person who can give you the money to do your accessibility programming, just remember you're part of a global movement. And that's one reason I like Twitter, because it's a way of connecting to that. And there is a push, a historic push for accessibility back to where are we in time and history right now. And you're part of that. You're on this webinar. The IAAP is part of it. So beyond the U.S., we have the United Nations Convention on the Rights of People with Disabilities, and it's just a great convention. It's like a treaty. It's been ratified by over 175 countries. I don't have the exact number. If someone does, you can stick it in the chat box. And it's great on accessibility. You know, it's not implemented consistently around the world, of course, but there's great language. I really invite you to read it on the United Nations Convention on the Rights of People with Disabilities. On the website of the World Wide Web Consortium Web Accessibility Initiative, they have a policy page where they keep track of web accessibility policies around the globe. You can find that at w3.org/WAI/policy. I also keep a list. If you go to my website, lflegal.com, if you search for the word Japan, it pops up as the first or only article. It's also in the most read articles on the home page. So I just give that to you just to remember. Some of you may be working in global companies where you have to pay attention to it, but even if you're not, it's part of the what's the word? It's part of the motivation to me to not leave people behind when there is a global push like this. All these laws have remedies. Some have some kind of remedies, others have others. There's 4 basic types of remedies. Laws can require the fix, which we call injunctive relief. The fix, and we'll talk about what some of the courts are saying about that. And in my settlement agreements that have been negotiated in structured negotiation, the fix will include a standard, the training, using WCAG 2.0 AA, or in the future, the new 2.1. We'll talk about the best practices for the fix towards the end of this webinar, but that's part of what the legal remedies provide. There are attorney's fees provided in the Americans with Disabilities Act, which means that Congress decided that if a disabled person has a legal claim, that they shouldn't have to pay for their own lawyer, the way mostly in America you know that people pay for their own lawyers, but discrimination laws like the ADA, also race and gender, have what they call fee shifting, which means that if there's a discrimination claim, the organization that discriminates has to pay the attorney's fees. So that is a cost if you don't affirmatively and proactively do accessibility. That's one of the legal remedies that you face if you do get a claim. There's also damages to the individual person with a disability under some of these laws, not under the ADA, but under many of the state versions of the ADA, the state laws that I said were part of the foundation. And of course, part of the legal remedy, if you do a lawsuit, you could have a court watching over what you do. So just knowing that the remedies are out there is part of the motivation. Hey, let's not wait to get a claim. Let's do accessibility affirmatively and proactively. Okay, so does anyone have any questions about the foundation? We're going to next switch to the strategies, the lawsuits, and the settlement agreements. But if there's anything quick on the foundation, you can ask it now. You can also ask it later because we'll have other questions. But Kevin, do you want to wait a minute, or not seeing any? Should we move on?
Well, let's give folks just a few seconds to type any questions. And a reminder to those of you over the phone, if you'd like to ask Lainey a question verbally, you can hit #6, and that will unmute your line, and you can ask your question. So if you would like to ask a question, go ahead and do that now. I'll be able to see if you've unmuted, and we'll give you a little bit of time to ask.
I want to thank the captioner. I know I'm speaking fast. I feel there's a lot to share, and I want to at least give you a taste of what's out there. So I see one question coming in, so we'll wait and we'll take that, and then we'll move on to the strategies.
Hi, Lainey. It's Corb O'Connor, and a question for you is, do judges at all seem to be looking at the cases that are coming in from the standpoint of, is this truly a user who's being impacted by the inaccessible website, or is this somebody just sort of fishing for, yeah, they don't have some images labeled, but the site's still pretty usable?
Well, that goes to, we're going to talk about the cases under strategy, because that's one of the strategies. Just sort of a preview to that. Right now, most of the cases there's not that many that have gone all the way through the process. So like I said, when a case is filed, the person against whom it's filed has a chance to go to court and say, throw this case out, which is called a motion to dismiss. And at that stage, you're not really drilling down into the kind of issue that you're mentioning. They're looking at the big picture, which is like in the Blick case or the food, what's that called, Blue Apron case. They're looking at the big picture. The companies are coming in and saying, this case can't even be in court because there are no regulations. Or this case can't even be in court because the ADA was adopted in 1990 and it doesn't mention websites. So those are the kinds of issues that we're seeing discussed now. And just as a heads up, almost all the judges are saying the cases can stay in court, but they're not getting to that next level. Okay, so let's just take this one question here, which is, in 2017, there was a big push for federal regulations. Do you know where that stands now? It fell off the radar. Well, we did get an update to Section 508, which is for federal procurement. And if you want to know the whole long history, long with a capital L, of the 508, what they called a refresh, which we used to make jokes about because it took like 15 years to do it. But nonetheless, they did it. So 508 did get updated in either 16 or 17. But there are no ADA regulations. And if you came in after I talked about that, you can go back into the archive once this is posted, and you can see my slogans about that. No, there are no web regulations, but the ADA is alive and well. So without advocates and strategies, all that strong foundation is just that, which is why I have a picture here of a foundation with nothing on it, because we have a very strong foundation, but without advocates and strategies, that's all we have. So there are strategies for enforcing all the laws that we just talked about, and we're going to talk about some of them, some of the U.S. legal strategies. The first one is disabled people's advocacy. And I put that first because as a reminder that people with disabilities, they don't want to file lawsuits. They don't even want to do structured negotiation, kinder, gentler, collaborative way of resolving problems. They don't want to file administrative claims. They want things to be accessible. And every single day, people with disabilities are calling organizations, sending emails, filling out the feedback forms, asking for accessibility. And the best way, I know many of you are on this call to figure out how do we avoid getting involved in the legal system, because honestly, the law is just, it is a small part of accessibility. And all the work that all of you are doing and whatever your roles, that's the bigger part. But if you want to stay out of the weeds of the law, respond to people's advocacy efforts. Make sure when someone sends an email, it gets answered. Get the thing fixed. So many, even the lawsuits, the ones that, the previous questioner was referring to, someone tells you about a problem, get it fixed. So that's the first legal strategy, because the law is in everybody's pocket. And even if you're not going to a lawyer to use it, you have the right to say, you know what, I need access to this video, and it doesn't have captions. I need access to this document, and it hasn't been made accessible. Lawsuits, a strategy, always been a strategy, a bigger strategy now than it's ever been. Federal agency complaints are an accessibility legal strategy, and structured negotiation, which is a process I've been using with blind clients, blind organizations, and negotiating partners since 1995, which is a way of using the law in a collaborative, cooperative way. So let's talk about the strategies. I used to always start with structured negotiation. Of course, it's my favorite, but I have to be fair to the audience, and I know that the strategy number one right now is lawsuits. So lawsuits enforce civil rights. Lawsuits are important. The right under the ADA to file a lawsuit is one of the reasons why the United States is further on accessibility than many countries around the world. However, lawsuit strategy can be misused, just like any other strategy. It's really important to separate those two things and not throw the baby out with the bathwater. Lawsuits have been really critical in establishing the ADA as a law that can be used for web accessibility, and the fact that there might be lawsuits, like in every single field of law, misuse of the lawsuit or lawsuits that you don't think are fair doesn't mean that lawsuits don't enforce civil rights. So I think that's really important to remember. And don't forget, the lawsuit strategy can be misused on all sides. Company can get a lawsuit. They can hire a very aggressive lawyer and decide to fight in ways that aren't productive and that hurt the overall effort, just like lawsuits can be filed by lawyers who perhaps might not investigate as much as they should or whatever. So all around the table, the strategy can be misused, but lawsuits enforce civil rights. So let's see what's happening in the lawsuits. The foundational lawsuits, like I said, I can't any longer cover every lawsuit that's out there about web accessibility, although if you go to the legal update tab and you go back, you can see everything posted that from, I think I started doing the legal updates in writing in 2014, and you can see when I tried to cover every single lawsuit, and you can go back and look at a lot of the history with links. But there's too many lawsuits now and too many results, both good and perhaps questionable. So now we have foundational lawsuits, and I identify those as the Target case, which was in 2008, really the first big national court order to say that websites that are connected to a physical place have to be accessible. That was 2008. I want to give a shout out to my negotiating partners, including Bank America and many other organizations you can see on my website who we did our first agreement with them in 2000. There were other agreements done by other lawyers starting in 2000. NFB did a settlement with Amazon, I believe Amazon or eBay that year. I can't remember. So there was a lot of work going on in the space starting in 99, 2000, but 2008 was pretty much the first court order. Okay, so Netflix, another foundational case, important case brought by the National Association of the Deaf about captioning. The early litigation was primarily brought by blind people because an inaccessible website for blind people is a complete showstopper, total exclusion. The door is shut, to refer back to the door open or the door shut. As more and more digital content was through video, the needs of deaf site users became more apparent because when a video is not captioned, same thing, the door is shut. So Netflix is an important foundational case because it held that you don't need to be connected to a physical place. Target, the website was under the ADA because Target had stores. Netflix is streaming only, and the court, and that's another, you can go back and find the order online. It's a very nice order explaining why you don't need to have a physical place for Netflix videos to have to be captioned. Miami University, I put here as foundational. There's been a lot of good work with universities to make sure all aspects of educational programs are accessible. Miami University of Ohio is the most recent one. There's others, again, if you go, I have some resources later on how to find the ed cases, but also if you look on my website, you can find some of the early ones. There's a lot of good voting cases. Scribed is like a Netflix of books, and that also is a beautiful court order. I mean, some of these court orders you can read like a novel or a short story, should I say, about why it's so important for digital to be accessible, and the Scribed one is a very good one like that, and Scribed is completely online, no physical place. Seattle Public Schools I have up here, that was a case by a blind mother who didn't have access to her kids' math homework because the school site wasn't accessible. And I like that just as a reminder of who the users are. So that's what I call foundational. Some recent developments, there was a settlement, a testing service for the bar examination for lawyers called Barbary. That's settled, which is why I have a very anxiety-producing picture here for lawyers of a clock and someone filling out bubbles and taking a time test. There's a pending case against Los Angeles Community College where they had to have a court fight about whether organizations can sue for accessibility, and the court said yes. It's a case brought by the NFB, and they said yes, the NFB can be the plaintiff in the lawsuit. These are the kinds of issues in structured negotiation, or if you decide to work collaboratively with any claims you get, you can bypass some of these issues that really cost a lot of money when they're fought over in court. There's some lawsuits about employment websites, application websites. There's a lot of cases recently filed in New York against schools. There's a lot of cases against credit unions pending. I have to do an aside on the credit union cases because it's a little bit of a heartbreak for me. There was recently a very good settlement with a credit union in Washington State where there wasn't a lawsuit, where there was a good commitment to accessibility. The parties worked together. It was another very good lawsuit settlement. I'm not even sure if they had to file a lawsuit. It might have been a structured negotiation with San Francisco Federal Credit Union where the vendor of credit union technology was part of it, and they agreed to make it accessible. On the other hand, now there's a lot of lawsuits that has sadly turned the credit union industry into an opponent of accessibility efforts in the legal space. Didn't need to happen. So I want to give a shout out to the good work that some credit unions are doing to work with their customers. Ameritrade has a lawsuit. There's pending lawsuits on voting. The numbers, I know you want the numbers, so I'm just going to have one slide on the numbers. In 2015, there were 57 lawsuits about web accessibility. Next year, 262. Last year, 814. And since January of this year, there's been 1,000 web accessibility lawsuits filed. So it's harder and harder for me to, I really don't like the fear thing, but it is out there, and the best way to deal with the lawsuits is to have accessibility baked in, and we're going to talk about that. We're going to talk about that in 15 minutes. Kevin, I might need an extra minute or two before we get there. If you want the numbers and that's your thing, if you like the metrics, the Title III blog, ADA Title III, they use three little I's.com, by the Safar Shah law firm. That's where I got these numbers. They keep track of this, and that's where you can find more numbers. Here's some recent court orders. Winn-Dixie was the first case that went to trial where the judge said that the website had to be accessible. It was appealed. Then Winn-Dixie it's in federal court, went into bankruptcy. The appeal was what they call stayed or temporarily stopped while the bankruptcy thing was figured out. It's my understanding that Winn-Dixie's out of bankruptcy and the appeal is still there. So we should hear something. It's in the 11th Circuit, which is in Winn-Dixie was in Florida, so it's a federal circuit dealing with that. Hobby Lobby, Blick Art Materials we talked about, Blue Apron, the 1-800-Flowers. There's a Domino's Pizza case that is one of the few cases where the courts did throw the web case out of court. There's other pizza cases, don't ask me why, where the judge said they could stay in court. That Domino's case is also being appealed, and that's in the 9th Circuit, so we should, which is in California, we should be getting some higher court opinions on these things. Oh, yep, here's Pizza Hut. I have a picture here of a hand dropping money into a trash can because most of the cases where there was an effort to throw the case out of court early, the plaintiffs are winning. And to file a motion to dismiss, again, this is not legal advice, but in my view, based on all these court orders, it is a waste of money to fight it at that level. So it's much better to put the money into accessibility. Beyond motions to dismiss, like I say, right now we're in the early stages. Most of the court orders are about motions to dismiss. But we're going to get past that, which is why I have a road going through trees. We're going to see other things coming down the road. And so there's two cases that got past the motion to dismiss. Often they settle right after that. But here, two cases that got past the motion to dismiss. One was in California court against a company called Whisper Lounge, the restaurant. And in that case, the judge, motion to dismiss is when they just say, throw this case out of court, and if you lose, you have to go back and fight about the case. Summary judgment is when the judge early in the case says, you know what, one side or the other wins. So in this Whisper Lounge case, it was a summary judgment in favor of the plaintiff, blind person. The person got $4,000, which is the amount in California under the state law, part of the foundation. The court did say you don't get $4,000 every time you go to the website, but they did give the person $4,000, probably their attorney's fees. I haven't seen the motion on that yet. The judge said that the site should comply with WCAG 2.0 AA, which is the standard being used in the court cases and settlements. Basically, the case was about an inaccessible PDF menu, perhaps other things as well, but talk about something that would have been a lot cheaper to fix. So I have a picture of the menu there. So that's Whisper Lounge. If you Google it, I haven't written about this yet, but on the ADA Title III blog site that I just gave you, they did a piece on this Whisper Lounge case. You can read the court order. Sorry, the text is slightly off the slide. In this case, the company said, well, we have an email address, and we have a phone number, and people can call, so our website doesn't have to be accessible. And the judge said, that's not enough. So I have a picture here of an old telephone with a no on it, because we all know that phone doesn't equal web, but you know, the law is slow and technology is fast, and the law looks backwards and technology looks forward, which is why we have a little bit of a disconnect in some of the conversations in the court orders, and one of them was this, like, is a court going to say that a phone is enough if a website's not accessible? And I'm hoping that this Whisper Lounge case, even though it's just California, it only affects it doesn't even affect all of California, it just affects those parties in that district, but still, maybe it'll have that argument go away, because we all know that the phone, only in a law case would anyone be arguing that the phone is equivalent to a website. Winn-Dixie, that was the federal court. There was a judge trial. Again, the judge said WCAG 2.0 AA. The judge said the third-party vendor material has to be accessible. That's important. There was mandatory training required and automated testing. Again, I have articles about Winn-Dixie on my site. You can find the link to the whole order. And again, this is on appeal. So we don't know what's going to happen with the appeal. And they ended up with a 3-year court order. Another reason to do it yourself proactively is not to have a judge looking over yourself for 3 years, which is what happens when you lose a lawsuit, one of the remedies that can happen. A couple unusual twists to look out for. There's a whistleblower case against Teach for America where someone claimed they were fired because they were pushing for accessibility. We don't know what's going to happen with that. There's one case I'm aware of where the web developer was sued. There's a, I don't know, restaurant, some sort of thing called Wet Willie's, and the website was designed and hosted. It said on the front page, website designed and hosted by Sabre Technologies, and Sabre Technologies was sued. I'm not sure what's going to happen with that. I don't think anything yet. Here's a couple of big pictures. In a case in December 2017, quote, the court today joins the growing number of courts to hold that commercial websites qualify as public accommodations within the meaning of the ADA, such that the ADA's protections extend to blind people who claim discriminatory access to websites. Big picture, too. Some courts are still saying you have to be connected to a physical place. They call a nexus. Other courts say you don't. And the truth is websites are global. So the fact that you might have a legal argument in one part of the country that you're not connected to a physical place doesn't mean you have it all over the country. So I'm not that moved by that argument. Judges agree with that. And again, this was from the Blick. It was from Judge Weinstein. I think it was Blick, but it was definitely him. A rigid adherence to a physical nexus requirement leaves potholes of discrimination in what would otherwise be a smooth road to integration. I love that. Put it in your pocket. Potholes of discrimination in what would otherwise be a smooth road to integration. Okay, big picture 3 twice. Sorry about that. Don't be distracted by the court losses because the legal roads are leading to access. As of last year, 11 out of the 13 times where companies went to court to get the case thrown out early, the plaintiff won. We're going to expect backlash. Backlash is already starting. Just a little bit of heads up, there was a letter in June to the Department of Justice by 103 Congress people asking for action about too many websites. In Oklahoma, they passed a state law that said, I think it's Oklahoma. Yeah, if it isn't, I'll put a note up in the archive that you can't sue about web access in that state. The Credit Union Association, I told you, is launching a campaign against the websites. just this morning, I got an email. I don't know if anyone's on the phone on the call from this, but there's a consulting company called MicroAssist, and one of the staff there, Jack McElhaney, has an amazing email list that I encourage you to look at if you really want to be like super up to date. I don't know how Jack does it. And just this morning, he said that there was another state attorney generals sent a letter to the Department of Justice asking for action. So there's a lot of things happening, and I'm just hoping that the civil rights aspect of this can be heard above the fray of all the conversation about the lawsuits. My message on the lawsuits is spend money on access, not on lawyers. With a pile of money, spend money on access, not on lawyers. Remember that digital access is more than websites, and there have been cases about kiosks, restaurant kiosks I have a picture of here. I have an article on my website. You can find it in the legal update about what the law is saying about the kiosks. Most of these cases are settling, but there have been either filed as lawsuits and then settled or done in structured negotiation to begin with. The city of New York got a lawsuit about their public kiosks. Restaurants did an agreement on their kiosks, bringing in the vendors. So digital access is not just about websites. It's greater than websites. The law is slow, like I said, so most of the legal activity is focused on websites, but the advocacy activity is beyond that. Here's a link to the article I wrote. It's at lflegal.com/2018/01/kiosk18, and that'll give you what's happening in the kiosk space. Okay, there's a lot of government agency activity. People can file complaints with the Justice Department, State Attorney Generals, Department of Ed, the Federal Communications Commission, and the DOT. With the DOJ, they have a website up. It's at it's at ada.gov/access-technology, and you can see all the DOJ activity from 2004 to 2017, and some of the cases are still citing all these activities that the Justice Department did when we had a strong civil rights Justice Department under the previous administration. They're being used in current court cases. So even though these agreements and Justice Department activities aren't happening now, they're happening and they are there. Yeah, let's make that a link. Thanks, Kevin, for putting up the kiosk link. Maybe you could also put up the access-technology, ada.gov access-technology link, because there's a lot of great work that you can read in there. Hasn't been much done by the Department of Justice under the current administration, but in 2018, they did do a case against the city of Denver where they required web accessibility, so that's still there. And like I said, today's courts are relying on yesterday's DOJ. Department of Transportation settlements with airlines about kiosks and websites, those are happening. Department of Education, we could do a whole webinar on that. There were many, many complaints filed about web accessibility in K-12 and higher ed. Departments of Education, there was backlash against that number. They changed the rules on filing. There is now a lawsuit against those new rules as being inconsistent with the gold standard the Department of Education has been over many decades in enforcing civil rights of students. So we'll have to see what's happening with that. Structured negotiation, I'm just going to do really just like in a minute. Bank America, Major League Baseball, Anthem, Blue Cross, San Francisco Credit Union, Walmart, these are all companies who chose to work in collaboration to resolve their claims. Charles Schwab, Lyft, The Motley Fool, E-Trade, H-E-B Grocery. I have a page on my website called Settlements, and you can read all the agreements. I think transparency is very important in this space, and as much as possible, I post the agreements. Things are public. People can look and see what's happening. I'm going to skip this next section because we have to get to the best practices to avoid any legal strategy, but I just want to put it out there that the collaborative tools of structured negotiation can be useful beyond the legal context. I'm doing actually a workshop with Sean Henry in Madison, Wisconsin in August on this, collaborative tools for designers and developers committed to accessibility and other issues. So I'm going to just not talk about the slides and get to them. You can be a dolphin and be an advocate. You don't have to be a shark. And that's what my work's been for 20 years. Anyone who wants this presentation, I can put that together again. But I want to talk about the strategies. I want to talk about the good strategies that Bacon Access have a picture here of cookies, because when I presented this with Microsoft at CSUN last year, we actually had cookies for the audience, and the cookies had lots of chips of different types, chocolate chips and M&Ms and nuts and various things. Oh, no nuts for allergies, but various things, because everybody has a role, and all of you are in different roles. Like I said at the beginning, I don't know what they all are. Thank you, Andrea Orvik. Email me offline, and I will talk to you about the presentation on collaboration for developers and designers. Good strategies, Bacon Access, whatever your role, you can contribute to this, and this is the best way to avoid these lawsuits. And if you get one of the lawsuits, like the previous caller, or the question about, well, are they real lawsuits? Are they real disabled people with real issues? If you have good strategies at Bacon Access, you can avoid the lawsuit, or you have a very good line. Again, not legal advice, very good line of defense if you happen to get one. So best practices that come out of the structured negotiation work I've done, settlements that people who have filed cases, court orders. I've synthesized those. I'm not saying every court has said this. I'm not saying every settlement agreement. You know, most of the litigation ends up settling, of course. I'm not saying every one of those settlements or every structured negotiation settlement has these best practices, but they're in one of those. They're part of the legal environment, and more importantly, they're part of companies, let's, take Microsoft, such a leader in this field, that are doing without waiting for legal activity, just knowing that it's good for business, it's good for civil rights of disabled people, it's good for people who aren't disabled. So best practices. Make sure that your plan is not just web and it's not just mobile. There needs to be a audit of all technology, because you can get one thing good. You don't want it to be whack-a-mole. Oh, we did web, but we didn't do mobile, or we did the app, but we didn't do the kiosk, or we did the kiosk, but we're a healthcare company and we didn't do the health technology in the patient room. So it has to be web, mobile, everything tech. The standard used in most settlements, most court cases that talk about this, is WCAG 2.0 AA. We now, thanks to the very, very hard work of the W3C Web Accessibility Initiative, have a WCAG 2.1. It hasn't filtered its way into any legal, into the legal space yet, but I really invite you to make sure that you look at it for your organization and incorporate it as much as possible, because it fills some really important gaps. It makes some really important fillings of gaps in WCAG. Having a web accessibility coordinator and knowing where that person sits so they have the most authority, and having a person who uses that authority well is a best practice. Having an independent consultant, one of the things I've seen, people get a lawsuit and they're like, oh my God, we got a lawsuit, we got to hire someone. They run out, they hire the first person they talk to. No, don't do that, because accessibility consultants, just like all accessibility work, you need to treat in your organization just like any other vendor. You need to get references, you need to interview more than one, you need to understand the landscape. I've seen too many people throw good money, well-intentioned good money, just hire someone quick, first person that knocks on the door, without really thinking what is the best consultant for my needs and for our culture. So having an independent consultant can really be key. but make sure it's someone that works with you in a way that you need it. Having an accessibility policy, so important. Having training. I put a picture of a phone here, because an old phone, not that old, not a rotary dial like the phone that's supposed to substitute for a website in some people's minds, but a push-button phone, because early on I was working with a big company, and we knew the blind people were calling and not getting good advice, and we sat in a room with the company. We said, well, why don't you just pick up the phone and call? It was just a phone like this. And so we sat around the table, and they called their own customer service number, and they got bad information. And, I'm a big believer in show, don't tell, and that was a really good example of that. So when you have your training, make sure you test your training. If it can be as simple as making a phone call, what do they call that, secret shopper kind of thing, call up your phone and see what kind of answer you get. So who needs to be trained, what training, by whom? Having a person with a disability involved in the training is so important. That's another thing I learned a long time ago. I was working with, when I was doing architectural cases before digital, we had a blind person train, it was with a stadium, and train stadium help, and it was just, in 10 minutes, because people need exposure and people need understanding, people need the relationship, the person-to-person connection. So if you can have a person with a disability involved in the training, all the better. And like I said, check it out. Homepage accessibility information page. It's really important to have information on your website that explains what your accessibility commitment is. I used to call that accessibility information page, and I have a link on my website to a post that I keep up to date. You can read 50 different accessibility information pages from companies, some good, some great, some not so great, give you a feel for the kind of page that companies are using in schools and public agencies. The European Accessibility Act is requiring this. They're calling them accessibility statements, and I'm going to start using that word too, so we have global consistency. Don't reinvent the wheel, which is why I have a picture here from Whirlwind International of a wheelchair rider helping someone adjust a wheel in a wheelchair. So I recommend another way to get to the post on my website is you can search the word Hitachi, because that's the only post in which it shows up. Make sure you have contact information, and that if you have an email address or a phone, that someone's going to answer it who knows what they're doing. So much of the work I have done in the past 20 years in this space has started when a blind person calls a company and they are told, even to this day, this is not ancient history, can't someone help you with that? Again, back to the privacy and confidentiality. Can't someone read you that? You got to make sure that people are trained and you have good information on your accessibility statements where people are going to get the kind of information they need to avoid getting in the legal space. Adding accessibility to performance evaluations. If someone's responsible, whatever their role, it should be something they're evaluated on. Use a testing tool. That was most recently I put here, there was a settlement with CMS, the Medicare agency, talking about a testing tool. That's another whole topic, another whole, I'm sure IAAP has presentations and webinars on testing tools. There's good information on the Web Accessibility Initiative site. There's going to be a whole testing symposium that I'll be speaking at in November. So again, with the testing tool, don't just run out to the first vendor who knocks on your door. Get an understanding of what's out there. Find something that fits with your culture, your budget, your needs. Make it something that's going to be integrated and something that's useful to you. Usability testing, such an important best practice. It really should have its own 5 slides. Having disabled people as part of your UX design and testing, there's no substitute for that. And the Department of Justice settlements and our settlements and litigation settlements, and I believe at least one court decision is starting to recognize that. Vendor contracts, so important. I did a post. You can find it at lflegal.com /2018/04/vendor-contracts. I wrote this with Eve Hill, who's a lawyer for the National Federation of the Blind. We had it published in Business Law Today for business lawyers, and it's just sort of a high-level look at what should be in vendor contracts about accessibility. Again, not just an add-on. Same way you'd treat confidentiality and security in any of your contracts. Anything that's delivered, make sure it's tested for accessibility. Again, part of baking in accessibility into your programs and processes. In higher ed, I want to recommend, I know IAAP is doing a higher ed series. I don't think you've done, Kevin, has that already happened, the higher ed series? I don't think so.
It has not. That starts in September.
Okay, so I really recommend that. I'm sorry I don't have a link on it, but you're going to get a lot of good information there from a lot of really great speakers. Another place to look is at 3Play Media. Paul Grossman, who worked for Department of Ed for 30 years and is a very good source of information on higher ed accessibility. If you look for him on the 3playmedia.com site, he did a legal year in review recently. So between that and what IAAP is going to do in September, really highly recommend to get the best practices and most up-to-date for higher ed. Culture, company culture, so important. Again, I have to turn to Microsoft. And for those of you who haven't read Satya Nadella, the Microsoft CEO, he has a memoir, autobiography. I really recommend it because you can see that culture is both top-down and bottom-up, and at Microsoft it has really started between him and Jenny Leigh Fleury, the Chief Accessibility Officer. You can really, in that book and following Jenny and Microsoft's activities, you can see what it means when a company has a culture of accessibility. I am starting to keep track of organizations that write about their accessible culture. You can find a link at lflegal.com/2018/05/accessibility-culture. I invite any of you who have written or work for organizations that are touting their culture of accessibility to share it with me, because one thing I've learned over the years is most organizations don't like to go first. We do work on accessible prescription labeling, which is another digital aspect. I mean, I've done 90 minutes just on healthcare technology and accessibility. So if any of you in healthcare, just know there's another whole conversation we need to have about making sure healthcare tech beyond websites and mobile and kiosks are accessible. Why did I just think of healthcare? Because on the culture piece, if you don't have accessibility baked into the culture, new things are going to, hopefully new technology is going to be developed, and we need it to be accessible from the get-go. Otherwise, we are going to be playing catch-up for the rest of our lives. So having a culture of accessibility is really the bestest of best practices that you can have. And I will go back over the notes, and those of, yes, the Starbucks signing store. Thank you for putting that in. That's another great example of culture. Starbucks just opened its first U.S. store with all its staff, who they call partners, but they mean employees and baristas, fluent in American Sign Language. And it was fun in terms of the global issue to read that that store in the U.S., which is in Washington, D.C., near Gallaudet, is the second Starbucks, and the first one to have a signing store was in Malaysia, So, you know, accessibility is global, and the best practices we can learn from each other all over the globe. Some resources. For higher education, there's a great list maintained by Laura Carlson at the University of Minnesota. I made a short link for it. It's bit.ly/higher-ed-law, and she does a great job. You can find the agreements, court cases, you know, judge opinions, complaints. So she does a really good job on the higher ed piece. I have an email list. Sorry, for those looking at the slides visually, I see some of the text didn't come out quite right here, but lflegal.com/contact. I don't send too many emails out, but I send some. It's another resource. And the ADAtitle3.com blog, which has the metrics. I don't have on here, but I want to say again that the microassist.com blog the email list of Jack McElhaney will, just like I said, this morning in came one email that had the Attorney General's writing the letter and also a link to a TV excerpt about too many web lawsuits. So I'm not saying, you could get depressed reading all this information, and I just want to give like a warning that, we need to know it, and I like doing these webinars to share what's happening in the legal space, but remember, like, what's in the pocket. We're talking about people's civil rights. The cases are going to be the cases. Some judges are going to say one thing, but the general direction is for accessibility. And yes, there's going to be some backlash, and yes, the disability community is going to be right there to make sure that backlash doesn't take over the big picture. Okay, my book, which the slide did have a picture of it but doesn't have any more, the book is not just for lawyers. The book really is a shout-out to the negotiating partners and the legal advocates who have worked in collaboration. You can read the stories and the strategies. It was published by the American Bar Association, even though it's not just for lawyers, and they're having a summer sale with 25% off with the code SUMMER25 on their website, which is Shop ABA. The book is on Bookshare, which is a library for people with print disabilities. It's part of the National Library Service for people with print disabilities, and it's also on Amazon, so I commend that to you. And I have a tab on my website, lflegal.com book. You can learn more about it. And I finished in time for some questions. So I put on the final slide the stay in touch. Again, I'm on Twitter at lflegal. I have the mailing list, and the website has updates, settlements. I do a lot of public speaking. You can see the speaking when information is recorded. I have the archives on the website. So you can find all that stuff on the speaking page. And again, I want to thank you for being in a community of people who care about accessibility, who are curious about the law's role. And I'll just leave you with one thing. When I did the presentation with Microsoft at CSUN, we did, best practices for accessibility. One of them I should put on these slides. The Microsoft lawyer said, diverse hiring disabled people. Because you know what? If you have someone sitting next to you that can't use an app unless it's accessible, you are much less likely to design an inaccessible app. And in our presentation, of course, we had law and compliance listed as a best practice. But you know what? It was down at the bottom of the list. Because if you do all these other things, yes, of course you have to meet the legal requirements and you want to be in compliance, but it should be a check against what your best practices are delivering. Try not to make the law the driver in a way of fear. Try to make the civil rights piece the motivation. And wow, Mel Johansson, thank you very much for that comment. The most valuable 90 minutes I've spent all year. Oh my God, thank you for that. Okay, so Kevin, do you want to take over with the questions?
Sure. We did have a couple of questions come in as we were presenting and going over that whole laundry list of links, which we will be sure to post to the handout page as well afterwards. So the first question we have is from CRB Ally. It was my understanding that although the ADA was enacted in 1990, President Obama strengthened it in 2012 to also include electronic infotech. Is that not so? Can you touch on what was updated in 2012?
The call could be referring, there was an update to the ADA Title III regs. Title III is a part of the ADA that covers public accommodations, which ironically is a name for private businesses that serve the public. And as part of the auxiliary aids and service language, auxiliary aids and service is just another way of talking about accommodations for people with sensory impairments. They did update that definition to include, I think screen readers wasn't in it before. It used to have older technology. So it could be the update. I thought that was in 2010, but I could be wrong. If you want to shoot me an email about that, I will double check on that, and Kevin can put it in the show notes or whatever you call it. And again, 508 was updated and refreshed to make it, the main thing that the 508 refresh did was make it consistent with WCAG 2.0 AA, which of course is, international harmony, especially U.S. harmony, is so important for organizations. So there might be something else, but those are the two things that come to mind.
Our next question is from Joe. Can you talk about any legal precedent when sites use third-party integrations? Example, a restaurant links out to Twitter or a dietary facts page that they don't maintain, but those other services are not accessible. Is the restaurant responsible for finding a new solution? How does accessibility law overlap/interact with other laws like that dietary facts have to be provided?
Well, I don't know anything about laws around dietary facts, but I do know I did a structured negotiation. Okay, on third-party content, I actually was thinking of doing a post on this to summarize where things are at. In the settlements, well, first of all, in the Winn-Dixie case, the judge said that the third-party content on the site had to be accessible. Again, that's up on appeal, but the judge did say that. Let me see if I can, I'm not screen sharing, right? So I can check my email. Because yesterday I was just asking someone about this, that the most recent settlement with the credit union, again, the credit unions can do such good work. The most recent settlement that the National Federation of the Blind did with a credit union did require third-party plugins or content added to the site. Mobile or certain channels after December 18 will conform to WCAG 2.0 AA. So there's a lot of, and the Peapod and H&R Block settlements with Department of Justice talked about third-party content. As far as I know, there's no legal rulings if you're just having a link that's taking your readers outside your own site. Ideally, it's very nice if you're doing a pop-up, and an accessible pop-up, of course, in that context, you do an alert that, just like you're not responsible for the privacy of sites you link to, you're not in control of the accessibility. So as far as I know, there's nothing requiring just if you have the pure link, but if you have the information imported into your site, then there's going to be more and more legal. I'm sure the judges are going to get to this, and the settlements are starting to get to it, and we have it in our structured negotiation settlements that content, if you're going to put the content on your site, then you're responsible. That was a asterisk, these webinars are not legal advice question.
We had a comment from Corb asking if we could share the name of the website for Jack McElhaney. We did post that link down lower in the chat. We had another comment from Andrea Orvik mentioning that she took a wheelchair design class at SFSU with Ralph Hotchkiss, who designed the Whirlwind wheelchair.
Yes, Ralph is a friend of mine. That's why I thought to use that picture. To don't reinvent the wheel. Don't reinvent the wheel. Yeah, and don't reinvent the wheel. That's why it's so great that you guys are all on here and you're aware of the resources, the ones I've given, the ones that IAAP has, because there is so much out there, and we need each other. We need to know what each other's doing. That's why I'm so happy to read all the Microsoft blog posts and hear about the Starbucks store, and yeah, because there's so much happening in the space that's good. And because I'm a lawyer, I'm always, people want to know what's happening in the legal part. And yeah, we can't let the legal part overwhelm us, except to remember that we're talking about inclusion of disabled people, and that's, why we're all here to begin with.
We did have a couple of additional comments. Lori commented that there is also a higher education Slack group that includes a space for accessibility discussions. Andrea commented that CSUN has a MS program for assistive technology and human services for anyone interested. It's all online. And then Lori commented, the University of Illinois offers an information accessibility design and policy certificate program. And then there are some links to, I'm assuming, those programs mentioned. And then finally we have Chris Law, who posted a link to the testing symposium, and Angela, who asks, so who is responsible for the website being accessible, the third-party developer or the website owner?
Well, that's where we get into procurement. The website owner is ultimately responsible in the contract to purchase the technology. The accessibility has to be spelled out. And, you know, I'm not a business contracts person, but I would be very surprised if business contracts don't spell out who's responsible if something goes wrong. And that's one of the things we talk about in that article we wrote for Business Law today about really being specific in your vendor contracts about what is going to be delivered, how it's going to be tested. I got feedback on that article we wrote for Business Law, and someone said it's really important to have the testing be done by someone independent of the relationship, which I thought was a really good idea. And who's going to be responsible if there's a problem 6 months down the road? So these are all things that have to be worked into the third-party vendor contracts to make sure that there's a seamless experience. Because don't forget, we're talking about users, you know, users as job one, users as first. It's a seamless experience for them. They don't know. We don't know when we go to a website what part is third party and what part is first party, second party. You know, it's just content on a website. So if you're delivering content, the basic idea of the law is you can't deliver it for some and not others. And if you just remember that core principle, it'll get you far down the road.
That's currently all the questions we have in the chat. Those of you who are connected over the phone, we will give you a couple of seconds now to unmute your line. Again, the command for that is #6. So if you have any questions, go ahead and ask now. I am not seeing anyone asking questions. So I think that concludes our webinar. Thank you so much for everyone who joined us, and especially for bearing with us as we got through a couple of those technical issues at the beginning. And thank you for the captionist for sticking with us as well. And then a huge thank you to Lainey. This was a fantastic presentation and very enlightening. Seeing lots of other great comments coming in about thank you for the great info, things like that. So huge thanks for that.
Well, you're very welcome.
Just a couple.
Oh, go ahead. Mm-hmm.
No, go ahead, Lainey.
Well, no, the only thing I was going to say is you missed one comment that I saw that Chris put in here that I will be keynoting the testing symposium, so I feel like I should mention that because the testing piece, as those of you who are involved in it know, so important. I might call the topic the good, the bad, the ugly. I'm not quite sure yet. Or the great, the good, the bad, the ugly. But I'm looking forward to that too. And I really want to thank the IAAP for having me and for doing this series and for all of you. And I hope you stay in touch. And thank you very much.
Thanks, Lainey. Just a couple of little housekeeping things before we totally wrap up. We do have a feedback survey. So if you go ahead and select the link that's right there at the top of this slide, it will take you to a brief survey where you can tell us what you thought about this webinar. If you've attended any of our previous webinars, you can also fill out the form for those as well. We just ask that you submit one form per webinar that you attend. So we'd love to hear back from you, and I'm sure Lainey would appreciate the feedback as well. As I mentioned at the beginning, this webinar has been recorded and will be available on our website as an archive. We record every webinar that we do, so please take a look at that second link for archived webinars and see what we have in our library. I'm sure there's lots of things that might be relevant. Actually, as we were just discussing, the who's responsible for third-party website content, and negotiating those contracts. We have a great presentation on how to use the VPAT 2.0, so that might be relevant to some of you. So just take a look at that. And then we also have a couple of upcoming webinars. So on August 15th, we have How McEwen University Created Accessibility Learning Resources and the Impact on Student Perceptions of Their Learning. That should be a great presentation and really ties into the higher education accessibility webinar series that's coming up starting in September. So we encourage you all to attend that. And then on September 26th, the IAAP annual webinar series will continue with authoring tools, accessibility, new US and European requirements. We hope to see you there as well. That concludes the session today. Thank you again to everyone. There's nothing special that you need to do to close Adobe. You can just close the Adobe Connect window. Those of you who are just connected over the phone, all you have to do is hang up. And thank you for attending. Everyone have a great day.